We are EngageSCV, and our goal is to unite entrepreneurs in Santa Clarita. And our mission is to raise awareness and bring education and inspiration for technological innovation in Santa Clarita. So we like to host events like once a month or so to topics that we deem are relevant to what to the cause of building startups and bringing just innovation in the city in any way, shape, or form we can. So big shout out to Julia Shiro for allowing us to do this thing here at the library. And today we have Erica Bristol to tell us about intellectual property, and she's going to walk us through on how to file for trademark, like a step-by-step thing. So I'm going to welcome Erica.
Appreciate it. Thank you very much. My name is Erica Bristol. Just a little bit of background about me. I'm an intellectual property lawyer and a mediator, so I actually go into court and help parties resolve intellectual property disputes. And one of the reasons that I wanted to do this presentation for SCV Engage is because intellectual property is one of those areas that when you're a startup, you don't have the money and the resources to learn about it or to hire legal counsel so that you can prevent lawsuits and litigation, and so you can protect your own IP, and so that you understand what your employees and independent contractors are building and creating and using in their companies. So the purpose of this presentation is 50,000-foot level. We're just going to talk about what is intellectual property and why it's important, and the 4 different types, and why entrepreneurs and business owners should know about it, and a couple of the issues that I see with founders when they're getting together and creating partnerships or LLCs, and sometimes they don't work out, and what happens to the IP, who gets to use it. So we'll talk a little bit about that. And then at the end of the presentation, we're going to do something that I think is very valuable for startups. We're going to learn how to select a business name, branding, right? How do you select a product name, a service name, and what should you do before you roll out and use that name? Because that's a big problem. A lot of small businesses come up with fantastic product and service names, just wonderful. They think they're just the best thing ever. They roll out the product, and then they get a cease and desist letter from a trademark owner saying, you're violating my trademark rights. So we want to protect against that, okay? So, since I'm an attorney, this is what we do. I have to give a disclaimer, because all good paranoid attorneys will have a disclaimer like this at their presentation. If they don't, they're not paranoid enough, and you don't want to use them. So, I'm an attorney, but nothing in this presentation should be deemed legal advice. Please consult an appropriate professional for your particular situation. I really want to be the voice at that automated checkout counter at Ralph's. Use PinPad to complete transactions. One of these days, I'm going to find out who is that person. I know all of those pre-recorded standards. The thing. Okay. So first of all, let's talk about what is intellectual property. Before we get started, I want to get my cell phone because I want to show you something. Everybody in this room uses intellectual property every single day. When you see that word, don't think it's this big technological thing that only lawyers and engineers deal with. It's an everyday thing. So take my cell phone, okay? My service is T-Mobile. Who here has T-Mobile? So you know how bad their service is, right? T-Mobile is a trademark. So when you think of T-Mobile, you think of a brand of phone service, right? That's what T-Mobile is. When you look at the screen and the layout and some of the icons, those are protected by copyright. So you're seeing it every day. The chips in here, the computer chips, may well be protected by patent, right? And the chips and the technology and how they came about developing it, and Nokia and the manufacturer, Nokia is a trademark, their process for marketing, or what's in their contract, how their customers buy and when they buy the chips, that could be a trade secret. So we have all 4 types of IP right in here, right? You go to 7-Eleven, you reach in and you get a Coke, right? A Coke is a trademark, right? Microsoft's marketing materials, marketing plan, and business plan, how they're going to get money money away from Apple is a trade secret. This is everyday stuff. So when you guys think of IP, don't panic, don't freak out, don't think it's something you'll never understand. Everybody uses it every single day. Okay, so IP is a type of property. So real estate is real property, right? IP is intangible type of property. So real estate, you can touch it, goods, you can hold it. IP are legal rights to something, but you can't touch or hold or feel it. That's all it is. So it's usually intangible. The legal rights are for something that you can't touch or feel. The owners usually get exclusive rights. They get to stop other people from using it. Sometimes for a limited period of time. For example, copyrights don't go on forever. They're for a limited period of time. Patent rights don't go on forever. They're for a limited period of time. Other rights go on forever. So if you keep using your trademark, it could go on forever. If you keep preserving something as a trade secret, it could go on forever. So some rights go on forever, some go on for a limited period of time. Most of the time they're exclusive, for only you can use it and can stop other people from using them, okay? They're protected by federal, state, and international law. So patents are only federal law. We have no state patent law. Copyright, only federal, so you'll be in federal court if you have a copyright issue. Trademarks and trade secrets are federal and state law. So some things are protected by federal, some things federal and state, and some international, okay? So you need to know there's lots of different laws that protect IP. Okay, why is IP important? Even if you're a small startup business, your IP could be very valuable. Sometimes IP is valuable, sometimes it's not, right? You may create something and you get a patent in it, but nobody wants it, right? Okay, so you have the right, but what do you do? Nobody wants to exploit it. Sometimes you get a patent and it can generate millions of dollars, right? So sometimes IP is worth a lot, sometimes it's not. If you have a trademark for a product or service and nobody's buying it, I guess the trademark's not that valuable, right? Because it's not connecting the clients to the product. So IP for your startup business, it helps you be creative, because once you create something, you're going to have exclusive rights to it. And so you're going to want to be more creative, because then those things can generate money, right? It helps you be innovative. Think about Apple and Samsung, how they're competing with each other all the time. They're constantly filing new patent applications to try to carve up the market for themselves, and we all benefit most of the time. Sometimes we don't. Competition, right? You've got a competitor, that competitor is being innovative, and they go file a patent and it stops you from doing something, stops you from moving forward. So it helps you be competitive, helps you get an edge on your competitors. So that's one of the reasons IP is really important. It's an asset. Your business owns real estate. That's an asset on your books, right? Your business has accounts, money, that's an asset. IP is an asset on your company books. So Coca-Cola's trademark is worth about $50 million. Who knew that? $50 million for a trademark, for a tangible, right? It generates revenue, right? So when I buy a Nokia phone or with a T-Mobile service, they're making money off of me, right? So I think, who are the service providers? T-Mobile, who else is out there? Verizon, who else is out there?
AT&T.
Right. How do you know these names? How do you know these names, right? They have got you connecting that name with the product. There's probably a million other service providers. There probably is. Do you know their names? You don't know their names. They spend the most money getting that name out and advertising and promoting it, and now it's sunk in your brain. So when you think T-Mobile, you think of a brand of mobile phone service. AT&T, a brand of mobile phone service, a brand of landline service. That trademark is worth a lot of money. It connects you to the product. You'll go and buy it. When you think of Verizon, do you all think that's the best service out there? Do you guys hear they have a really good reputation? That's goodwill. So you're thinking, when I think Verizon, I think really good product. I can't tell you how much money that's worth when people think your product is good, and that's called goodwill. And when they tell a friend or when they buy it. So that's the value of trademark. Okay, so it generates money. Employment. These stats are old. I don't have the new stats yet. 40 million jobs and 27.7% of all jobs in the U.S. economy deal with some form of IP. And that was back in 2012. It's surely greater now, right? The US economy, back in 2010, it was almost 35% of the US GDP. You all can imagine how much IP is affecting our lives now, right? 60.7% of the total US merchandise exports involve IP. That's a lot. And this quote from one of the reports, the entire US economy relies on some form of IP because virtually every industry either produces it or uses it. That's so true. It's important for you as a small business. It's important for the multinational corporations. Okay? So it makes money. So there are 4 types of laws that protect IP, and there are 4 different types of IP, and we'll go into those. But I just want you to know, copyright's federal, trademark is state and federal. So if you're somebody like me who's going to go and pretend we're going to look up the law and act all smart and impress our friends, which I do all the time, you can't just stop with state. You got to look both state and federal. Trade secrets. We're going to talk about a new federal trade secrets law. Who's heard about that new law? Anybody? Oh, one person, yeah. There's a new federal trade secrets law. Trade secret law used to be state by state, right? There was a federal law, but it was only criminal, so only the Attorney General could bring an action. Now, there's a civil action, so people can sue you in state court and federal court. And there's some things you have to do when you create NDAs or when you create employment agreements or invention assignment agreements. You've got to put some special language now in your NDAs because there's this new whistleblower clause. And if you guys heard about that, because it's under this new law, if you don't put that information in and you want to sue somebody, you won't be able to get punitive damages. Do you guys know what punitive damages is? Damages just means money. Whenever you see the word damages, we're talking money. Punitive means to punish. So it has nothing to do how much you were really harmed as a business. They're just giving you extra dough. Lawyers jump with you when you see punitives, okay? And you can get attorney's fees, which means normally when you have a lawsuit, if you win, you take a piece of that money out of your lawsuit, you pay your attorney. Attorney's fees means you get the judgment and your attorneys get the money separately. So when we see attorney's fees, we're like, yes, we'll take the case, okay? So I just want you guys to know, when you see a contract that says the prevailing party will be entitled to attorney's fees, like, okay, I'll represent you, yes, 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 yes. Because that means we know we're going to get paid, okay? Patent law is just federal, so you'll be in federal court, and we talked about international treaties, just so you know. Okay, why should you guys know about IP? Issue spotting. You're coming along, and you see one of your employees talking to one of their friends on email and giving away some of your, your new marketing plan. What are you doing, right? Very often, marketing people, your marketing and your sales team, will take some secret marketing information about what you're going to roll out next year, and they go talk to a prospective client and say, wait, next year, we're going to roll out this. And they're like, what are you doing? Don't go tell these people. You don't have any confidentiality. You're trying to get them to sign an agreement, and your employees are giving away the trade secrets, right? They're giving away that secret information, and you don't know. So, issue spotting. Your employee leaves, they set up shop, and their business is just like yours, using your innovations. What's going on there? Your employees are putting things on thumb drives and doing stuff at home. Your employee has a side gig, right? So you just need to know, you need to be able, as management, you need to be able to spot, is that a trade secret? Is that a copyright? Is there a copyright problem there? It's just issue spotting, so you can go talk to your lawyers or talk to somebody who knows. So you can identify these things, okay? Awareness of your company IP. How many in here have businesses that you're operating? How many know exactly all the different types of IP you have and are tracking it? You should know your IP. Do you know your brands? Do you know your trademarks? Do you know the copyright works that you have? Do you know what's a trade secret and how to protect it? Right? Do you have any inventions that could be protected by patent? You should know that. If you are a corporation and you are the CEO and you're running this thing and you're a technology company and all this IP is floating around unprotected, might your shareholders be a tad bit mad? Right? Might the board be a tad bit mad? If you get sued for infringement, how long are you going to keep your job? Right? So people don't think about it like that. It's job preservation. It makes you look good if you go to the board and say, I think we have an innovation that can be protected by patent. We should talk to the attorney. Oh, well, that's wonderful, bro. It makes you look good. So you should know your IP also because you don't want to get sued. If you can do things to lower the risk of getting sued and to make more money off your IP, well, that's what you put on your performance review before you get that bonus. Do you think as an attorney inside, I didn't scramble from 6 months out to do everything I could so my bonus looked good at the end of the year? Of course I did. So there's a little self-interest in protecting your IP. Chain of title. You need to know who created it, how to change hands of ownership. So if you want to sell your company, we're not going and looking back and saying, oh my gosh, we never really owned that in the first place. So that's chain of title, making sure we can track every person who owned it, okay? Especially when you're selling the business. The lawyers, that's what I did. I just dug through all the documents. Okay, you owned it, let me see, did the employee transfer the invention over to the employer? Let me see, did you file the assignment? We're going to look and make sure you own everything that we're buying. So that's important for selling the business. Management, if you have patents, if you have trade secrets, you shouldn't be thinking this, you should be thinking this. 3-year, 5-year, 10-year plan, right? Some patents expire after 15 years, some expire after 20. You got a license, that license is going to end because there's cases on the books that say when your patent dies, your license dies. What are you going to do with money? How are you going to replace that money? Can you create a new innovation to protect around that old patent? It's long-term planning, and protecting your IP should be part of your business plan. Is your intellectual property in your business plan? How many people put their IP in their business plan? Oh, see? That's why I'm here. Avoid infringing the IP rights of others. Employees and your independent contractors, people you hire to build things for you or do things for you, often don't know the first thing about IP. They're the first ones to go out on the internet and grab videos and grab open source software. Who knows what open source software is? They grab open source software, and unless you know what the license is connected to that software, they may be breaching that license. And if you breach the license, that could result in copyright infringement. Hundreds and thousands or millions of dollars, right? Employees don't know this stuff. That's why you educate and train your employees. IP litigation is increasing. Do you know that for a patent case, to take a patent case all the way to trial, for $1 million or less in damages, it could be $650,000 in fees.
That's all? That's higher.
$650,000, I'm like, yes! For over $25 million, it could be a good $1 million just in attorney's fees and costs to take that to trial. Do you have insurance coverage? Many IP infringement acts are not covered by insurance. So you're going to open up your pocket and pay out because something your employee did. How long are you going to keep your job? How long is your business going to stay open with that kind of money you're paying out, right? What if somebody takes your IP? It's not just all about being sued. What if somebody takes your IP? Can you get a lawsuit going? Right? Did you protect it? So now you had these trade secrets and somebody stole them, but did you do everything to protect them? So now you can't get your money. And also, if you're aware of your IP, you may be able to make $50,000, $100,000 more than you made before because you didn't even know you had that. So it's really good internally for your business to make money with your IP and avoid getting sued. Okay? Risk is all about risk management. Okay? Any questions on this? Okay. What are the most common types of IP? Really, when we talk about IP, there are 4 types: copyrights, trademarks, trade secrets, and patents. Some people feel that the licenses for those things are also IP, but these are the basic 4 types, okay? So, what's a copyright? A copyright is an exclusive right granted to an original work. So people get these words all wrong. They say, can I copyright like that? No. The copyrights are the rights in the thing, okay? So it's rights. A copyright is a set of rights, a set of exclusive rights in an original work, an original creative thing, and we'll explain what that is, in a tangible form, okay? So it can't be in your head. If you come up with a song and it's in your head and somebody else records it, you can't sue them for copyright infringement. How are we going to prove it was in your head? We don't have that technology yet. We'll get there, right? But you've got to take it out of your head because the courts, we can't prove it. You can't prove it. You've got to get it out of your head. It's for a limited period of time. Right now, it's the life of the author plus 70 years. For lawyers, that's a limited period of time, right? So you create a song, you die, your heirs get those rights for 70 years, okay? After that, it goes into the public domain, which really means you can't enforce your rights anymore, and anyone can use it. So right now, there are works, maybe at the turn of the century, I think Sherlock Holmes just went to the public domain. You guys hear that? All those stuff. So if you're going on the internet and taking videos and putting it into your product, taking articles, putting it in your product, taking pictures and putting it in your product, you're probably infringing somebody's copyright. Who knew that? Let's all be honest here. Who thought everything on the internet was free to use without permission? Be honest. Do you know, a lawyer, sorry you guys, I'm animated about this. A lawyer told me she thought things on the internet were free to use. I said, are you kidding me? Huh? I should have called State Bar. And she was serious. I'm like, oh my God. But she wasn't an IP attorney. Right. She did commercial. You know those commercial lawyers. So it goes in the public domain. So if you want to use something on the internet, you got to find out who owns it and get permission. If you don't want to get permission, there's something called fair use, where you can use something without permission. But you better talk to an attorney, because it's not a bright line, clear yes or no test. And there's some factors. You want to make sure you meet those factors. And if the attorney says it's in the public domain, have at it. You know, most classical music's in the public domain. Okay? All right. So here's examples of copyrighted works. Your training materials, right? The words of your training materials, right? Those are creative and original. Your software, right? All those ones and those, whatever the heck you guys know. That's original and creative, all the strings of stuff in a tangible form. Music, the lyrics and the music that you write. Audio recordings, videos, movies, choreography, sculptures, those are all creative things in a tangible form. So for most businesses, your things are going to be maybe pictures that your business takes for your website, maybe articles and blog posts. If you're a technology company, your software can be protected by copyright.
Would logos be in there too? Or no?
Absolutely.
Under education and training materials, say you wrote like a step-by-step process, and someone literally like just copy your step-by-step process.
Okay, so there's two elements there.
Yeah.
The literal words, the line-by-line words, that's protected by copyright. The process or the method or the procedure, copyright does not protect that. It just protects the literal, whatever it is, in tangible form.
Yeah.
Maybe patent would protect the process if it's patentable, but not copyright.
But the
So
words
copy-
like so.
The words on the paper, copyright protects that. The process that's reflected, no.
Yeah. So it's that can be a gray area, because then they can say, well, I just wrote it so many words, and if they switch one word, then.
So what you need to do is, anytime you have IP,
Yeah.
you have to go down your list. Is your copyright protection, trademark, trade secret? Because one thing could have two pieces of protection. For example, the logo. The logo is a creative, original thing in tangible form, so that's copyright, right? But if you're using it as a trademark, it can also be trademark protection. So you always got to go down the
So you
list.
have to actually go and do both of those then
Well,
separately?
and we're going to talk about whether you can decide. You have protection in both. For trademark, there's some extra steps you can do, which you can register it, but we'll talk about that, okay? So, any questions on this? Any questions about things you have where they're protected by copyright? Mm-hmm.
If you have something that you want to use that's on this list, how do you
That
go
somebody
about-
else's?
Well, you don't know that.
Right, that's hard.
It's not yours.
Right.
Okay, so where do you go to seek
To find out who
a
owns it.
release once you find out who owns it?
There's a couple of things. You can go on the website, go all the way down to the bottom, see who owns the website, if there's material there, or contact us. You can call them, right? Another thing you can do is do a who is search. Who knows what who is?
A what?
A who is search. A who is search will tell you who owns the website and the URLs. So it's a special search, and it'll tell you who owns like that URL, you know, ericabristol.com, and you might be able to contact that person, and because sometimes who owns the website is different from who owns the URL. Not often, but sometimes it's different. So you can go find out who owns that web address and go ask them who owns the work. The third thing you can do, this is the more difficult thing, is go search the Copyright Office database. All right? But you have to know how to search. You can't see the thing, you can't see the video or hear the music on the copyright database. It'll just have a title and the owner. So you'll have to have more information. The picture will have to have a title or something. Then you go search for that on the Copyright Office database and see who owns it there.
So is the one database that you're talking about Actually, two, is that in here somewhere?
It's not in here because this is the basics,
Okay.
but feel free to ask me afterwards and I'll show you how to do it, okay? Any more questions on this, the list of things? Anything that you're wondering about is protected by copyright? Okay, let's keep going. How are copyrights created? As soon as you create that thing, and as soon as you put it in tangible form, that's the instant minute you have copyrights. You do not need to register the work to have copyright protection. Everybody gets that wrong. The minute you take it out of your head and you put it in a tangible form, that's the minute you have copyright protection. Who knew that? Who thought you'd mail it to yourself and all that crazy stuff? No, don't mail it to yourself. But let me tell you what mailing it to yourself does. Mailing it to yourself does not create any copyrights or any legal rights. Mailing it to yourself creates evidence of when it was created, a date it was created, and maybe evidence of who the owner is by that little, postmark says this date. That's all it does. It doesn't give you any copyrights. So go ahead and mail it to yourself. It's just going to be evidence as to who owns it and when it was created. That's it. Okay? So you put it in a tangible form, paper, CD-ROM, maybe computer software that stores code. It's out of your head and in some way that can be perceived, a recording. That's it. That's when you have copyright protection. Any questions about that? Any confusion about that? You get it out of your head, you put it on a way somebody can see, hear, touch, feel, instant protection. That's when you have the legal rights. Don't let anybody tell you anything different because they don't know what you're talking about.
The question I have is, if you have it, on the CD, say, for instance, and there's a copyright office in Washington, do you have to send them a copy?
Okay, so now we're getting a little bit technical. Kind of, sort of, the copyright law says everybody's supposed to upload their stuff. Forget about that, okay? This is my suggestion for uploading stuff and registering. It's called registering it with the Copyright Office. I would suggest registering things that make money, that are one of a kind, right? That are special, are unique, or your flagship product, and that you would sue somebody if they made a copy of it or used it without your permission. Or if you need to document that for some reason, it's relatively cheap. It's like $55 a registration. So if you write a book and that's your business, why wouldn't you why wouldn't you register it? The benefits of registering it, you get extra legal rights. And I think it's in here somewhere. But you get extra rights. And you have to register it before you can bring a lawsuit anyway. So, I wouldn't go register it and you make a blog post and go register it. Man, are you going to sue somebody over your blog post? Maybe not. Go register it quick and then, But you have to register. Let me tell you, there's another thing. You have to register the work before somebody infringes or 3 months before you make publication, which means you allow people to make copies, and I don't want to get too much in detail of that. If you don't register it within 3 months of publication, you won't be able to get attorney's fees, which all the lawyers want, okay? And there's something else called, I'm just telling you, when lawyers see that, we're like, okay, we'll take your case. Or something called statutory damages. I'm going to tell you what that means really quick. Normally, you sue somebody, you say, Your Honor, I was harmed $50 million. The judge says, prove it. Give me the documentation to show me you were harmed $50 million, right? Statutory damages, you say, Your Honor, I was harmed. If the judge says yes, you don't have to prove anything. The law says, all right, we're going to give you X amount per infringement. How wonderful. You don't have to prove how much you were harmed. And so when I do mediations, it's all about statutory damages. People are trying to talk about, we can do statutory damages. That's a whole threat, right? So in your mind, if the work is super, super important to you, if you would sue, just kind of say, all right, when I'm done with my final version, I'm going to register it within 3 months. That's the best thing to do. Or register within 30 days, whatever your policy is, so you can get those attorney's fees and statutory damages. Okay? Any questions on tangible form? So forget all this registration stuff that creates rights. Registration gives you extra rights. Get it out of your head, put it on paper, software, that's when you have copyrights. Okay? Who owns the copyright? The general rule is whoever creates it owns it. That is the general rule. Who he or she who creates it owns it. All right? There are some exceptions. When an employee creates work during the course and scope of their employment, the employer owns. That's an exception. The other exception, if they do it outside, it has nothing to do with your business, they don't use your materials, the employer owns, okay? Independent contractors, I want you guys to think about this when you're hiring people to do graphics for you, to create things on your website for you. Anytime you're asking somebody to create something creative, logos for you, right? We all do that. They own it. Did you guys know that? They own it, unless it's something under the copyright law called a work made for hire, and you have a written agreement that says it's a work made for hire, or they assign the copyrights to you. Under the work made for hire statute in the copyright law, there's only about 9 things that qualify as a work made for hire. So what do all the attorneys do? We're just going to say, okay, we're all going to agree it's a work made for hire, right? But just in case it's not a work made for hire, we have this backup clause that say you're going to assign all the rights to us. So if you guys have ever seen that language in the contract that says it's a work made for hire, but if it's not, we're going to sign it, it's because they're not sure if it qualifies under the copyright law. Okay, that's what you do. So before, okay, there's case law in different areas around the country. Some of them will allow you to do a contract after they've created it, some will not. I think in where we are, you got to have that contract in place first. Do not let anybody create anything for you. No logos, no articles, no books, no graphics, software, nothing. You have your contract in place, same as a work made for hire, or they're assigning any rights to you, okay? Don't do it on afterwards, do it up front, and have it signed first before they touch anything for you. Got it?
I just want to make a comment for that. Same with like people who have websites, because I help on the side help people with websites, and I've noticed people are like, oh, the web designer changed my password to the WordPress site. Oh, he's not letting me. It's like you allowed him to take the pictures, you allowed him to design it. It's really his.
Well, picking a picture, you know, the picture's already created, right? So getting into a website or not, I always put in the contract that you will always provide me with all passwords, and you will not change anything without my client's permission, so we don't have those issues. And I don't know how websites work, but if there's a way to have a master password where you can override everything, you got to make sure that you have it and not the person who's developing.
So a tip for that is have your domain with one company, so whoever your domain is, and then whoever is building it, you're hosting on a self-guide.
Or get somebody you trust, right? Or, and make sure you own that URL, but that's a whole other thing that we're not talking about. So, thing to take away from here, your employees create something, you own it if it's during the course and scope of employment, okay? You should know what your employees are creating. Independent contractor, you're gonna hire somebody to create it, get that contract signed first, take all those issues off the table, because if your book or your software becomes a bestseller, and they come in and say, I never gave you the copyright, what are you gonna do? A court may say, hey, that's not fair, you waited all this time, we're gonna say that that person gave you a license, but they still own the copyright. Take all those issues off the table, you're not doing nothing until you sign the contract. And if you're not sure how that language should be laid out, hire an attorney. Please don't drop this stuff. Oh, I've seen the most crazy stuff. You want, I cannot do this. You want the right language. You're paying for this stuff, right? You could pay for something and your company goes down the toilet. All right, then who cares? But if your company blows up, look, nobody sues until you start making money, right? Who sues if you're not making any money? You don't have any money. Why would I sue if you don't have any money? I want to wait till you're a millionaire. Like, that song certainly sounds like my song, right? Don't we all hear, right? Take these issues off the table. Get the contract before. So founders, if I'm in along, you've got your one genius engineering friend and he's coming up with this invention. Let's make a company, right? Don't we all do that? Okay, I'll do the marketing stuff. Okay, let's look it together. Well, Joe's, you got that creative type who's driving you nuts, like, okay, this is gonna work out after you right, your friend is crazy, right? You can't deal with the business, I can't handle it. Then you guys all walk away. Who owns the creative work? Who owns it? Did you guys have an agreement amongst yourselves that you would all own it? Or that if you created an entity, you were gonna give the work to the entity? Did you guys put any of that in writing? Big tech startup problem. So you got one guy who's creating the patentable work, and you have everybody else working and going out marketing, and then you break up and you don't have any agreement, or you haven't assigned the patent to the company, right? So anything before the company exists, if you do not have an LLC, if you do not have a corporation yet, the people who create it own it. And unless you have a written contract that says we are all going to put this IP into the company, how are you going to enforce it? right? So you should think about, before you're creating your LLC, if people are creating things, having an agreement amongst yourself of what's gonna happen. When you get your equity in the LLC, your capital contribution, what you're giving the LLC in exchange for your shares, is that patent, right? Is that marketing materials, whatever your services, whatever that IP is, the person should be putting it into the LLC so there's no question later. Any confusion on that? Okay. That's a big issue. Is registration required for copyright? No, but it puts the work on a searchable database. It makes it harder for people to say you didn't know, so you can get more like intentional infringement and use more money. It gives you extra legal protections that we talked about, and you have to apply in some places and have an actual registration in other places to bring a lawsuit. So go ahead and register if it's worth the money. Okay, what does the C symbol mean? It's just copyright notice. It's telling the world, I'm claiming copyright in this work. Why do you think that's important? Because if you copy my work anyway, I'm going to sue you for intentional copyright infringement, and you're going to have to pay me punitive, and my attorney and I are going to the Maldives. That's why. If you have a copyright notice on the work, how can somebody say I didn't know? They know who the owner is. So in this example, you give the C, or the word copyright, the date it was created, and the name of the copyright owner. You go copy my picture and that's on there. How can you say you didn't know?
Isn't Disney famous? We don't have to.
Let me tell you something. Disney.
Everybody, basically.
Anybody who's a multi-million-dollar or multinational company who makes their money from content, like Disney, is going to have people searching the internet and computer programs searching the internet and something called DRM, Digital Rights Management, which is embedded technology into their content to find who's copying it and misusing it. So if you're going to steal something, don't steal from Disney, don't steal from Microsoft or Google or all those people whose bread and butter is content and copyrighted works.
There's a story that Disney went after like the daycare center
Okay,
using
they'll
their
go
characters,
down.
which is mom and pop.
They'll go down. I did a mediation with a very big entertainment company where this retired guy was taking old movies off of VHS and putting them on the internet and just licensing them. They were like sharks. They would not let this guy go, okay, just don't do it again. They made him pay out of his little security check. They don't play because they want to set an example. They want to set an example that this is important to them. And if they didn't, their shareholders could say, why are you letting all this content go? You're here to make money for us. You should collect, right? They have a duty to their shareholders to protect their IP. As do all of you, if you own companies and if you're on boards, you have a duty to protect your IP. All right, let's keep going. Any questions? Infringement. You use somebody else's work without permission? Litigation is very expensive. You have that statutory damages. As little as $250 per infringement, up to $100,000 per infringement. You got $100,000? You got $100,000? I got $100,000. And your insurance company, because a lot of infringements may be deemed willful, you're not going to have insurance coverage. So hopefully you have a company instead of it's just you, because then they're going to go put a lien on your house, right? So you have to know how not to infringe other people's stuff so they can't come after you. The fair use is, you didn't get permission, but you have an exception. You guys go Google fair use on the internet. I'm not going to get into that because it's complicated and even lawyers fight over what it means. But it's just basically a 4-factor test. The court looks at these 4 factors and decides whether it's fair for you to get to use it without permission because there's a public policy or greater good reason for you to get to use it, okay? So, but you need to get a legal opinion if you're going to go try to pull that off. All right, here's this. I got it off the internet, so it's free. No. Call me as a mediator, call me when you get that letter. I'd be happy to be a mediator. I'm joking here. I gave the copyright owner credit or disclaimer. You see that on YouTube, no copyright intended. What the heck is that? You already copied it. So giving somebody credit doesn't get you off the hook. You have to have permission. I only use a small portion of a song, just like the hook. So using a little bit doesn't mean you're safe because it could be the golden nugget of the work. You copy the hook off a song, that's the most important piece of the song, right? All right. I helped somebody else infringe this line. I helped them do it, but I didn't do it. Contributory liability. You knowingly helped somebody else do it. I'm just the employer, as my stupid employee. I didn't know what they were doing. Vicarious liability, you're going to be liable for somebody else based on your relationship. I mailed the copy myself. That creates copyright? Nope, does not. I love when I hear that. That was so old. That's like from the 80s. I can't believe people are still saying that.
Wouldn't putting it down on paper create the copyright?
Exactly.
Okay.
That's it. That's all you gotta do.
It just,
Put it in tangible form. You write that book, it's done.
when worded like that, it makes it seem like it's a negative to mail it to yourself, but it's just.
I know, but
actuality.
because people think that they're creating legal rights by mailing it. You're just creating evidence if somebody sues or makes a claim. All it is gonna be evidence of when it was created, and maybe it'll help prove that you created it, but it's not, doesn't create the legal rights of the work. Do you understand the difference? So if you write a book, you own the copyrights. Copyrights are the right to make a copy, the right to make derivative works, which means take a piece of this and build something else with it, the right to display it on the internet, the right to sell or license it. Those are all the rights that you get. So there's like this bundle of rights. If you make, let's say you take Prince's CD and you put it in an envelope and mail it to yourself. Do you own Prince's rights in the music? No, right? You might try to say, well, this music was created on this date because look at the postmark and it was in my envelope, but that's not gonna prove you created that music on that tape. Do you see what I'm saying?
Does the same thing work for registered? It's basically still,
I can take Prince's song and register it, because the Copyright Office doesn't go do research on what you
Yeah.
register. It just puts it on a searchable database,
Yeah.
and it gives you those extra rights.
and what about like if you have some copyright and then you register it, do you put the R and C together, or you just one or the
Put
other?
the what?
Well, the logo, like, you know, if something's registered, you know, like when you put a.
R is trademark, we're gonna get to that.
Oh, okay.
R
is
means trademark.
okay.
C means I am claiming ownership in the copyright of the work.
Okay.
That's it. You can put a C whether it's registered or not. C doesn't mean it's registered, it just means I'm claiming ownership. Okay, any questions on that? Okay. Takeaways, you don't own it, get permission. If the work is created for you, get the contract signed first, especially with an independent contractor. And if you think fair use applies, talk to an attorney, okay? Trademarks, we spend a lot of time on copyrights because that's one of the biggest areas that businesses have. Trademark is words, Apple, phrases, I'm loving it. Colors, you know those two colors in the eBay or Google, those are copyrighted, that mean trademark protected. Symbols or logos. So Nike swoosh, trademark. Just do it, trademark, right? The word Nike, trademark. All those three things are trademark.
Do you need a copyright with a trademark, or could it be either or?
It can be either or both. Logo. If it's a creative logo, like the Starbucks fishy thing, I don't know what the heck that thing is. I've got to explain what drugs they're on when they create that logo. It is bizarre. Right? Have you ever really looked at that thing? Like, really? You just go in there, you're just paying attention. You're paying some crazy evil demons for some coffee. No, I like Starbucks coffee.
It was kind of obscene before they changed it.
I heard.
Kids.
It's weird. Okay, that's a creative thing. That's protected by trademark, right? They put it on some tangible form. It's also their logo, so it's also protected by trademark. So intangible form, that thing, copyright protection, as a trademark protection.
Just both of them.
So, or it can be combinations of those. You have to use it on the goods or services or in connection with the goods or services. Can of soup, you put your trademark on the can of soup. If you have services, you're using the trademark in your advertising and your marketing materials because you can't really put a trademark on services, right? Not attached to it. Right? Okay. It identifies and distinguishes sources of goods. It does not identify your company. It just identifies a source of goods. When I think of Nike, I think of source of athletic goods. When I think of Adidas, I think of a different source of athletic goods. That's all it does, right? It doesn't identify your company. It protects your company's reputation, whether they like goodwill, just means how much people, your customers like your product or not. That's it. You had a lot of goodwill like Coke, your trademark's worth a lot of money, okay? First to use wins. That's how you have to write. You're the first person to use the word or the logo or the phrase with those types of goods or services. So you have Atlas for tires and Atlas for jewelry. Tires are not jewelry. Those two completely different things. A customer who buys tires would not think that that same company is selling jewelry, right? So somebody can use Atlas for tires and another person can use Atlas for jewelry. There's no customer confusion. The whole reason we have trademark laws is to prevent against customers being confused as to who's offering the sale or good.
When it comes to a personality, you know, so I've heard some people say, you know, I'm the original person, like if there's a star and a person has the same name, I've seen it like duped out.
There's some things about protecting names and trademarks, and we don't have time to
Okay,
get into
okay.
because we'll be sitting forever. and
Okay.
We'll be pondering and
But it's
I'll
like-
put my hand like thing
Oh,
like this.
but the stars, I see the star.
Very
Okay.
clearly.
I didn't mean to,
We don't have time for that.
I didn't mean to open that, open that can
Yeah,
of worms.
it's not a can of worms, but there's more to it than getting your name as a trademark, because you've got to stop being, like, my name is Erica Bristol.
Yeah,
People can't, in order to have trademark protection, you have to stop thinking of me, Erica Bristol, the person, and like me, Erica Bristol, the design, the source of
Okay.
high-end goods.
Okay. That
Like
explains
Tommy
it.
Hilfiger.
That's,
You're not thinking of the man, you're thinking of a source of high-end clothing. So the
Okay.
name has to change.
that's good.
Actual use. You have to actually use the trademark to get protection. Actual use, okay? You can't just reserve it in your mind. There's a little exception under federal law where you can do an intent to use, and that's because big corporations sometimes spend $1 billion on their marketing campaign before they roll out a product. And if this little small fry came and started using it, they wouldn't be able to use that name anymore. So you can reserve the right in federal court for a period of time, but you have to have a good faith intent to roll that trademark out. Okay, so we won't go to that. How long do they last? They can be forever. You gotta keep using it, okay? This is VIP for small businesses. You have to do a knockout search first. Do not create a product name or a service name or even your business name without doing a trademark search. If you come up with Coke for soda, Coke's already out there, right? Everybody thinks their product name or service name is unique, and I tell you, go look, and half the world has already come up with the same idea. Got to do a search first. Search the internet. Search the domains. You want the domains, so you want to see if it's available. Search social media. Search, there's a state registration database, and there's a federal. You got to search both of those. There's something called a search report that you can buy that looks at state, federal, internet, Dun & Bradstreet. It goes through the whole thing, so you really have a good answer. Or you can hire a trademark attorney. Mm-hmm.
If you registered a name, a domain name, but haven't trademarked it, are you still protected? Can somebody still trademark?
You can own a domain and not own a trademark. You can have Sears.com, but you don't own any trademark. Now Sears may be able to get that domain from you if you had a bad faith intent to try to sell it back to them.
Mhm.
But if you just have Sears and you just wanted the name and you don't have any bad faith, they can't get it from you. Just because you have a domain doesn't mean you have a trademark. You have to be using it as a trademark.
Isn't that, isn't that what people do though, is when.
That's called cyber squatting, and then they can get it back, and there's like,
Yeah.
I think there's attorneys fees, and we're like, yes, take it.
Okay.
I see a pattern here.
So, get the domain, because if the trademark is available, and the domain is available, just go buy it, just go buy it, because somebody could buy it later, and it's $9 or $10, so what if you decide not to use it, at least you got it.
Oh, the
Okay?
trademark
That's all
is
the
just
big
$9 or
companies do, they go
$10.
buy the domains, and then they decide whether they're gonna use the trademark or
Oh,
not. Okay, types of trademarks, there's 4 types. Completely made up words like Advair, you know those pharmaceutical names, those are the best ones. The more the name does not identify what the product is, the better and more protection it has. So Advair. Arbitrary word like Apple for computers. When you hear Apple, you would never think of a computer. That's the next best. Descriptive words have little or no protection, like fast computer shop, and the reason is the trademark law does not want to lock down descriptions because then nobody can describe their products without infringing somebody's trademark. Generic bunt for bunt pig, ain't gonna get it. We're not gonna lock down bunt so nobody can use the word bunt anymore. This is out. So the last 2 you can understand why, right? I can't use bunt anymore. Get out of here. All right, is registration required for protection? No, but it puts your trademark in a searchable database. You can't say, I didn't know, because it's out there on a publicly searchable database, and it gives you extra legal protection. I think for trademarks, you can get treble damages, which is triple damages. I'll take your case, sir. Come sign right over here. And you guys think I'm joking. You know, as a plaintiff lawyer, they're going to look at your case and say, what's the chance of winning? And if you don't, you know, most of the time they're going to ask you for a retainer, like $5,000 or whatever. You guys got that? So the more it looks like they can win, the more likely they'll do a contingency agreement, which means if I lose the case, you don't have to pay anything. So that's what attorneys are looking at. How likely is it I'm going to win? If you've got a slam dunk, then maybe they won't charge you that retainer. Maybe they'll do contingency. You know, if I lose, you don't have to pay my legal fees. Okay? If you don't have a slam dunk, you're going to be paying a retainer. So get a slam dunk. Make it easy for the attorneys. All right, difference between TM, SM, and R. TM means I'm claiming this is a trademark. You guys ever see TM on stuff? You can do that whether or not it's registered. Whether or not it's registered, you can claim the trademark. As long as it's available, you did the search, you're the first one, you can use the TM. SM just means service mark, just a service. R is special, it means you have a federally registered trademark with the United States Patent and Trademark Office. You cannot use that R unless the USPTO gives you a registration.
Is that expensive to do?
Not really. Depends. Well, it depends. If you're broke, it's expensive.
That's all relevant.
It's like between, you know, is a 1967 GT Mustang 500 fastback expensive? Not to Bill Gates, but I can't afford one. All right. So it's like between $275 and $325 per trademark per class of goods. So real estate is a class, clothing is a class, right? So if you have a word, Nike, and the swoosh, that's two different logos, right? Nike has clothing. If they branch off into something else, that's another class. So you got one trademark, one class of goods is between $275 and $325. Okay, you renew it
That
every
ain't
10 years.
cheap. That's why they have it now.
State is $75. So there you go. But your protection's only in the state.
Well, now with the domain name that I registered, could I just say TM since I've already used it?
You cannot register it as a trademark unless you're using it as a trademark. 1-800-Flowers.com, they're using that phrase as a trademark. Even though it's a phone number, they're using it as a trademark. So they have it registered as a trademark. Your URL, you know, ericabristol.com, that's just an identifier on the web. That's got to be your trademark. Your customers have to identify you by that.
Well, if the URL is going to be my business name, then that.
It can be both. It could be. Like Sears is a trademark, and Sears.com is their URL. So it just depends. You have to think, am I using this to help customers identify and distinguish me from other
It would be,
persons?
so that.
So we need to talk about that a little bit more. Because
Okay.
you need to make sure you're using it as a trademark.
Okay.
All right, trademark infringement, you're using someone else's trademark without permission, or you're using it in a way that makes an improper affiliation or endorsement or approval. So you take somebody's logo and you stick it on your website. Does that look like they approved you, you know, you're affiliated with you? That's another source of trademark infringement. Okay, trademark takeaways, you gotta search before you use it. The more descriptive, the less protection. Consider registration, okay? Trade secrets, it's just information. That's all trade secrets is information, not generally known to the public. It gives you an economic benefit from not being known, okay? And you take reasonable efforts to keep it secret. So like the Coke recipe, the Coca-Cola recipe, KFC, your marketing plan, right? If your competitors knew what your marketing plan, they could compete with you better, right? Your customers list with pricing specifics and key personnel. If your competitors had that, they could compete with you better, right? That's a trade secret. Your business plan is a trade secret. If your competitors knew what you were planning to do, they could compete with you better, okay? How long does it last? Forever, as long as you keep it a trade secret. Companies never think about trade secrets. They never think about them, you know, unless they're in the know, especially small businesses. So they're not identified, so they go disclosing everywhere, and then they've just lost the whole protection because it's not a secret anymore, right? So how do you keep it secret? Keep your stuff confidential. When you get ready to do business with someone, you have to reveal one of your trade secrets, make them sign a confidentiality agreement, otherwise known as an NDA. Shred your confidential documents when you're done with them. Don't put it on your network, right? It should only be people who absolutely have to know about this. And you have a need to know, have a password on those documents, including your business plan and your budgets and all that stuff. And restrict access. Why put it on your network so all your employees can see it? They don't need, not everybody needs to see it. Okay, new federal law, Defense Trade Secrets Act of 2016. Now they can sue you in federal court, just not state court. There's this whistleblower notice that lets people know you can disclose when somebody else is stealing trade secrets or there's something unlawful going on. And so you need to put this information, you need to put the little phrase, if you look at the law, it has this little section that you put into your contracts. And that way, you can get punitive, punishing money, right, extra money, and attorney's fees. You don't have this little clause in your employment agreements, or you know, your employees need to know. You won't be able to go after those two things. And if your employee intentionally stole stuff, you want punitives and attorney's fees, okay? So I can't give you all this here, but just know, talk to your HR people, talk to your lawyer about updating any employment agreements you have, any NDAs you have, okay, or any assignment agreements where people are signing and getting confidential information, or using your trade secrets, okay? Patents, A patent is an exclusive right. It's weird, the law says an exclusive right to stop other people from doing something. It's not your exclusive right, it gives you a right to stop other people from making, using, offering for sale, or selling the invention in the US and importing it in the US. Inventions, just think inventions, discoveries, okay? Methods, procedures, things that can be protected under patent. What can be patented? A new and useful process, machine, article of manufacture, that means something that comes out of the manufacturing process. A composition of matter, like putting two chemical compositions or creating something new, or any new and useful improvement of one of those things. New means not already existing or patented. Useful has to have some use, even if it's low, but it's got to have some kind of use.
What about software?
Software can be patented. There's a big brouhaha right now because of some cases that came out that make it very difficult to patent certain types of software. So you've got to have a smart attorney, and most of the time the answer is going to be no, but it's not always the case. You have to let your attorney analyze it and make sure it meets some threshold tests. There was a case a couple years back called Bilski. You guys remember that? Of course you remember that. Bilski, that started the whole trend of software not being very patentable. However, didn't we say that software may be protected by copyright, right? So stick a copyright notice in your software, and then stick it somewhere obscure, and then if they steal the software, like, use copyright notice, right? Talk to an attorney. You can also register your software with the Copyright Office, but some people don't like to do that because it may have a trade secret in it. So you have to talk with an IP attorney about all the ways to protect your software. The U.S. is first to file, means you got to get to the patent office first and get that patent registered, get your invention registered first. Just like trademarks, you got to search, because somebody can have a patent, and if you roll out of this invention and start selling it, you didn't search, you're going to get that cease and desist, and call me for mediation services. You don't have to go to court. I charge $4.50 an hour. Registration is required. So unlike trademarks and unlike copyrights, you have to get a registration for patent protection, like it says right there. And utility and plant, those are two types of patents. Those are 20 years from the date you apply. Design is 20 years from the grant. Why does that make a big difference? Because you can apply and it can take years to get that patent. Sometimes it takes them a long time. So it's not 20 years from the date you get the grant. For those two, it's 20 years from the date you apply. So make sure your patent application is beautiful so you don't have that trademark attorney at the USPTO taking forever to get that patent through the system. Okay, after that, it goes into the public domain. So if your company has a patent, you better start thinking 5 and 6 years ahead. How are we going to replace that revenue? How are we going to replace this technology? Can we create a new patent to protect our old patent? You have to think strategy, because you don't have a lot of time when it dies.
So is that why they create like the cell phones all the time? Just like
They're
updating?
constantly improving their technology and doing an improvement of their existing invention to protect it. There's something called freedom to operate, which means you have the freedom to go out and expand and do whatever you want from this patent. And you don't want people coming in and making an improvement around your patent. They can't use the patent invention, and you can't use the improvement, so you're at a stalemate. So they use that to make you negotiate. So you have to constantly think, how can I improve this invention? Because other people are going to be thinking it for you, especially if you're making a lot of money. Okay, after that goes in the public domain. So think of your licenses. If you're getting revenue from your patents, you better be having this in your business plan. Okay, patent pending means it's going through the USPTO. You don't have your patent yet. Patent or pat followed by a number means you've got your registration. Okay? Provisional patent. Everybody loves these dang things. All the provisional, it's like a placeholder. It doesn't give you patent rights. The only thing a provisional does is gives you protection from the start date of the provisional. It does not create patent rights. So you have 1 year from when you file that provisional to file a normal full-on patent application. If you don't, the provisional just goes away, you've lost your money, and you start all over again. Okay? Very often, startups go tell everybody about their invention, right? When you tell people about your invention, the clock starts running. You have 1 year to file your patent application, and if you don't, you may lose your patent rights. So you gotta get people to shut up sometimes inside the company. Your inventors go to this conference and they start putting all these slides up. I'm like, what the heck, right? They put the slides up of your whole invention and they're telling their colleagues. Their time clock may have started running. So the thing about patents is zip your lip till you talk to an attorney about how much you can disclose, If you follow provisional, you've got 1 year. If you're doing things to get investors, make them sign a non-disclosure agreement because you've got to keep it confidential, okay? All right, patent infringement, you use somebody's invention without permission. Patent litigation is the most expensive litigation there is. Go Google Apple versus Samsung and see how much they charged and see a $400 million judgment. Wouldn't you love that? I can't even imagine $400 million. To them, that's nothing though. To me, you guys would never see me and I would change my name. If I got $400 million, I would instantly change my name, change all my addresses. I would say family. I put all my money in a trust. Don't think of killing me because you ain't getting none. If you want some, you're going to have to follow these very specific guidelines for education and financial training. Y'all will never hear me.
You'll find you got family like Prince does.
You'll see me riding around with this Mustang GT like, that was, yeah, she was the one that. Okay, patent takeaways. Gotta do a search like trademark before you use or sell the invention. Keep all of your invention confidential. Make people use NDAs. Even your investors, even people who are creating prototypes for you, everybody should be under NDA till that application is filed. Litigation is time consuming, so do risk management. Don't roll out an invention unless you search. And if you don't know how to search the patent and trademark database, get somebody to search for you. All right, conclusion. That's 50,000 foot level, right? We didn't get into the weeds. IP is valuable for your business, even if you're a small fry. It is one of the greatest revenue generators in the US. It keeps your company innovative and competitive, and you have to have a plan for your business on your IP. The litigation can be expensive. There might not be insurance coverage if you're a defendant, and that will kill your business. And you'll be calling me, and all you're gonna do is help me grow. So it's one way or the other. People see me rolling in my fancy car or rolling yours. One or the other, okay? Takeaways. You should be thinking 4 things with your IP. You must be able to identify it. Your employees should be able to identify IP they create. If you can't, you need some education and training, okay? Track it. When your employees create IP, they should be telling someone so you can put it on a database, so you can have, you know what IP you have, okay? Protect it. With trademarks, if you let somebody have a trademark license but you're not watching how they're using it, you can lose your legal rights because you're not protecting your own IP. Enforce it. If you need to have an attorney send a cease and desist or if you need to sue, do it because courts may not enforce your rights if you wait too long or you delay. They feel, hey, if you don't care, we don't care, okay? Educate and train your board, your CEOs, your employees. Ask an independent contractor, do you know what intellectual property is? If they don't know, and they're creating something for me, I would wonder, right? Are they using third-party materials without telling you? Have an IP management plan. Your legal handbook, your company handbook should deal with IP. Employees should know what they can use and what they can't. They should have periodic education and training about IP. You should do a periodic audit every year or 2 to see if you have new IP and maybe you have obsolete IP, or do you need to plan for the future, like your patents are going to go out, you know? And it should be part of your business plan, okay? You need help, get help from an IP attorney. All right, any questions? All right, here's some resources. Copyright Office, Trademark Office, International is WIPO, domains, ICANN, California law, you can look it up. Look it up like you're really smart, you know, go look up California law.
I was reading on the patent website, since you can't patent anything that's obvious.
Right.
And for example, I was looking at apparel. So if someone wants to just design eyes, you can't really do a design.
Yeah, you know, fashion is a little bit difficult. You can get a patent for certain designs, but it's more complicated and you really need help with that. Okay? Patent's a little more complicated, but it's still doable. Questions?
What's Erica's contact information?
I am here at the benefit of the, I'll give you my card afterwards, but I can't market and promote to my little soft sheet. Because this is for the public, it's not for me. If you want me, come get me right here. All right, now here's the fun part. Here's the fun part. We are going to learn how to select and pick a trademark and register it.